Report of the Impeachment Inquiry of Joseph R. Biden Jr., President of the United States of America. Report of the Committee on Oversight and Accountability Committee on the Judiciary Committee on Ways and Means prepared for the U.S. House of Representatives 118th Congress in accordance with H.R.E.S. 918 August 19, 2024. 2. Executive Summary. The Constitution of the United States entrusts the House of Representatives with the sole power of impeachment. 1. When confronted with evidence that the President of the United States may have engaged in treason, bribery, or other high crimes and misdemeanors. 2. It is the House's responsibility to conduct an impeachment inquiry and, when appropriate, prepare articles of impeachment. In accordance with this obligation, and pursuant to direction from the House, the Committee on Oversight and Accountability, the Committee on the Judiciary, and the Committee on Ways and Means have been conducting an inquiry to assess whether sufficient evidence exists that President Joseph R. Biden Jr. engaged in impeachable conduct. 3. As described in this report, the committees have accumulated evidence demonstrating that President Biden has engaged in impeachable conduct. The committees have prepared this report to inform the House on the evidence gathered to date. First and foremost, overwhelming evidence demonstrates that President Biden participated in a conspiracy to monetize his office of public trust to enrich his family. Among other aspects of this conspiracy, the Biden family and their business associates received tens of millions of dollars from foreign interests by leading those interests to believe that such payments would provide them access to and influence with President Biden. As Vice President, President Biden actively participated in this conspiracy by, among other things, attending dinners with his family's foreign business partners and speaking to them by phone, often when being placed on speakerphone by Hunter Biden. For example, in 2014, Vice President Biden attended a dinner for Hunter Biden with Russian oligarch Yelena Baturina. 4. Following the dinner, Baturina wired $3.5 million to Rosemont Seneca Thornton, a firm associated with Hunter Biden. 5. Then, months later, as Hunter Biden and his business associates continued to solicit more money from Baturina, Vice President Biden participated in a phone call with Baturina and Hunter Biden where Vice President Biden told Baturina, "You be good to my boy." 6. Moreover, President Biden knowingly participated in this conspiracy. Based on the totality of the evidence, it is inconceivable that President Biden did not understand that he was taking part in an effort to enrich his family by abusing his office of public trust. The evidence also establishes that the Biden family went to great lengths to conceal this conspiracy. Foreign money was transmitted to the Biden family through complicated financial transactions. The Biden family laundered funds through intermediate entities and broke up large transactions into numerous smaller transactions. Substantial efforts were also made to hide President Biden's involvement in his family's business activities. Evidence obtained during the committee's impeachment inquiry also shows Hunter Biden and his business associates leveraged Vice President Biden's official position to garner 1 U.S. Const. Art. 1, 2, CL 5. 2 U.S. Const. Art. 2, 4. 3 HRES 918, 118th CONG, 2023, HRES 917, 118th CONG, 2023. 4 Transcribed interview of Devon Archer, HCOMM on Oversight and Accountability, at 58, July 31, 2023. Hereinafter Archer interview. 5 Transcribed interview of Jason Galanis, HCOMM on Oversight and Accountability and HCOMM on the Judiciary, at 83 to 84, February 23, 2024, hereinafter Galanis interview. 6 ID at 11. Favorable outcomes in foreign business dealings and legal proceedings. Several witnesses testified that Hunter Biden invoked his father in business dealings with Romanian, Chinese, Kazakhstani, and Ukrainian companies, resulting in millions of dollars flowing to the Biden family. For example, around 2014, Hunter Biden explored starting a joint venture with Chinese businessman Henry Zhao and his company, Harvest Fund Management, Harvest, a $300 billion Chinese financial services company closely connected to the Chinese Communist Party. 7. And when it appeared the deal may not materialize, he called his father for assistance. 8. Similarly, while Hunter Biden served on the board of directors of the Ukrainian energy company Burisma from 2014 to 2019, he utilized his father's position to relieve pressure the company was under from a government investigation. In doing so, Vice President Biden changed U.S. policy in order to withhold a $1 billion U.S. loan guarantee until Ukraine took government action to stop the investigation into the company affiliated with Hunter Biden. After leaving office, Joe Biden and his family continued their financial relationships with corrupt Chinese businessmen who would send the Bidens millions of dollars. President Biden's participation in this conspiracy to enrich his family constitutes impeachable conduct. By monetizing the vice presidency for his family's benefit, he abused his office of public trust, placing the welfare of his family ahead of the welfare of the United States. He also put foreign interests ahead of the interests of the American people. Indeed, precedent set by House Democrats in 2019 in their impeachment of President Donald J. Trump establishes that abuse of office, defined as the exercise of official power to obtain an improper personal benefit, while ignoring or injuring the national interest, is an impeachable offense. 9. Separately, the committees have gathered evidence that President Biden used his official position to conceal his mishandling of classified information as a private citizen. During his tenure as vice president, Joe Biden removed highly sensitive classified documents from the White House, despite having no authority to do so. Documents with classified markings were later found at the Penn Biden Center, at his personal residence in a garage, and at the University of Delaware. 10. The report of Special Counsel Robert Hur detailed how President Biden willfully retained classified material, shared it with a ghostwriter who was unauthorized to receive classified information, and utilized the classified information to draft a memoir for which he received an $8 million advance. 11. The Special Counsel's report, as well as the committee's inquiry, disclosed how President Biden caused White House employees to conceal his conduct and mislead the American people about his actions. 12. Finally, the committees have obtained significant evidence that corroborates many of the allegations made by the IRS whistleblowers with respect to the Justice Department's deviations. 7 ID at 9 to 10. 8 ID at 10, see also ID at 88. W had I overheard was looking for help to get it over the finish line, and it was the harvest investment into Burnham. 9 HR Rep NO 116 to 346, at 44, 2019. 10 Robert K. Hur, USD EPT of Just, OFF of Special Counts, report on the investigation into unauthorized removal, retention, and disclosure of classified documents discovered at locations including the Penn Biden Center and the Delaware private residence of President Joseph R. Biden, Jr., at 19, February 2024, hereinafter her report. 11 ID at 102. 12 See generally ID. From standard procedures to benefit Hunter Biden. The Justice Department allowed the statute of limitations to run on 2 serious charges facing Hunter Biden. The Justice Department prevented line attorneys from conducting key interviews and pursuing important lines of inquiry. The Justice Department tipped off Hunter Biden's attorneys about non-public investigative actions and implemented unnecessary hurdles and approvals for prosecutors to charge Hunter Biden. The special treatment for Hunter Biden, which only ceased at the onset of congressional attention on the department's investigation, may be a basis for impeachment, as the distortion of an official investigation was a basis in the prospective impeachment of President Nixon in 1974. 13 Additionally, the House need not show that the President directly ordered his subordinates to obstruct an investigation. In certain circumstances the President may be impeached for the actions of subordinate officials. 14 During the course of the impeachment inquiry, President Biden and his administration have failed to fully cooperate with the House's inquiry. The Biden-Harris Justice Department has instructed certain key fact witnesses to not answer questions and directed others to disregard subpoenas from the committees. The Biden-Harris White House has obfuscated facts and denied the committee's access to witnesses. President Biden met with Hunter Biden before Hunter's defiance of his subpoenas for testimony, and the White House acknowledged that President Biden was aware in advance of Hunter's actions. Here, too, precedent from the Democrats' 2019 impeachment is instructive. As a matter of constitutional law, Democrats explained then, the House may properly conclude that a president's obstruction of Congress is relevant to assessing the evidentiary record in an impeachment inquiry. NW Here the president illegally seeks to obstruct such an inquiry, the House is free to infer that evidence blocked from its view is harmful to the president's position. 15 Applying the precedent here, the House is free to conclude that the witnesses and information currently withheld from the committees are adverse to the president. The totality of the corrupt conduct uncovered by the committees is egregious. President Joe Biden conspired to commit influence peddling and grift. In doing so, he abused his office and, by repeatedly lying about his abuse of office, has defrauded the United States to enrich his family. Not one of these transactions would have occurred, but for Joe Biden's official position in the United States government. This pattern of conduct ensured his family, who provided no legitimate services, lived a lavish lifestyle. The evidence uncovered in the committee's impeachment inquiry reflects a family selling the Biden brand around the world, with President Biden the big guy swooping in to seal the deal on speaker phones or in private dinners. It shows a concerted effort to conceal President Biden's involvement in the family's influence peddling scheme. One witness explained that when it comes to mentioning Vice President Joe Biden's involvement, say it, forget it. Write it, regret it. 1613 Philip C. Bobbitt, Impeachment, a Handbook, 128 YALLJ Forum 515, 581, 2018. 14 CID at 581-82. The framers repeatedly stated that the president could be impeached for the acts of his subordinates, whether or not he directed them in their misdeeds. 15 HR Rep. No. 116-346, at 67-68, 2019. 16 Galanis interview at 120. President Biden acquiesced to and participated in his family's influence peddling schemes. Indeed, those schemes would not have generated millions of dollars if President Biden did not do exactly what his family members needed him to do: show up. He did so intentionally, repeatedly, and with the knowledge that his actions sent the message his family members intended, that they had access to Joe Biden and, in exchange for payment, anyone, even a foreign adversary, could obtain access. Given considerable member interest in the status of the inquiry and to correct false and misleading assertions, this report presents the state of evidence as gathered to date in the House's impeachment inquiry. The inquiry continues as the committees develop evidence and obtain access to information. The committees continue to seek relevant documents and testimony. Subpoenas to various entities remain outstanding. Whistleblowers continue to provide incriminating evidence of the administration's special treatment for the president's son. The Constitution's remedy for a president's flagrant abuse of office is clear: impeachment by the House of Representatives and removal by the Senate. Despite the cheapening of the impeachment power by Democrats in recent years, the House's decision to pursue articles of impeachment must not be made lightly. As such, this report endeavors to present the evidence gathered to date so that all members of the House may assess the extent of President Biden's corruption. Impeachment inquiry findings from 2014 to the present. As part of a conspiracy to monetize Joe Biden's Office of Public Trust to enrich the Biden family members and their associates received over $27 million from foreign individuals or entities. In order to obscure the source of these funds, the Biden family and their associates set up shell companies to conceal these payments from scrutiny. The Biden family used proceeds from these business activities to provide hundreds of thousands of dollars to Joe Biden, including thousands of dollars that are directly traceable to China. While Jim Biden claimed he gave this money to Joe Biden to repay personal loans, Jim Biden did not provide any evidence to support this claim. The Biden family's receipt of millions of dollars required Joe Biden's knowing participation in this conspiracy, including while he served as vice president. Joe Biden used his status as vice president to garner favorable outcomes for his sons and his business partners' foreign business dealings. Witnesses acknowledged that Hunter Biden involved Vice President Biden in many of his business dealings with Russian, Romanian, Chinese, Kazakhstani, and Ukrainian individuals and companies. Then Vice President Biden met or spoke with nearly every one of the Biden family's foreign business associates, including those from Ukraine, China, Russia, and Kazakhstan. As a result, the Biden family has received millions of dollars from these foreign entities. The Biden family leveraged Joe Biden's positions of public trust to obtain over $8 million in loans from Democratic benefactors. Millions of dollars in loans have not been repaid, and the paperwork supporting many of the loans does not exist and has not been produced to the committees. This raises serious questions about whether these funds were provided as gifts disguised as loans. Under the Biden administration, the Justice Department and Federal Bureau of Investigation, FBI, afforded special treatment to President Biden's son, Hunter Biden. Several witnesses acknowledged the delicate approach used during the Hunter Biden case, describing the investigation as sensitive or significant. Evidence shows that department officials slow-walked the investigation, informed defense counsel of future investigative actions, prevented line investigators from taking otherwise ordinary investigative steps, and allowed the statute of limitations to expire on the most serious felony charges. These unusual and oftentimes, in the view of witnesses, unprecedented tactics conflicted with standard operating procedures and ultimately had the effect of benefiting Hunter Biden. The Biden Justice Department misled Congress about the independence of law enforcement entities in the criminal investigation of Hunter Biden. Biden administration political appointees exercised significant oversight and control over the investigation of the president's son. Witnesses described how U.S. Attorney for the District of Delaware and now Special Counsel David Weiss, who oversaw the investigation and prosecution of Hunter Biden, had to seek 1. Agreement from other U.S. attorneys to bring cases in a district geographically distinct from his own, and 2. Approval from the Biden Justice Department's Tax Division to bring specific charges or take investigative actions against Hunter Biden. Despite the clear conflict of interest, Weiss was only afforded special counsel status after the investigation came under congressional scrutiny. The White House has obstructed the committee's impeachment inquiry by withholding key documents and witnesses. The White House has impeded the committee's investigation of President Biden's unlawful retention of classified documents, by refusing to make relevant witnesses available for interviews and by erroneously asserting executive privilege over audio recordings from special counsel Hur's interviews with President Biden. In addition, the White House is preventing the National Archives from turning over documents that are material to the committee's inquiry. Table of Contents Executive Summary. 2. Impeachment inquiry findings. 6. Procedural background. 10. The constitutional standard for impeachment. 11. Abuse of power. 11.2. Obstruction of justice or obstruction of Congress. 13. President Biden abused his office by engaging in a conspiracy to peddle influence. 15. The financial analysis of the Biden family's business activities reflects a pattern of leveraging Joe Biden's office and hiding Joe Biden's involvement, but Joe Biden played a critical role in nearly every foreign transaction investigated by the committees. 18. Evidence shows that President Biden was essential to the Biden family influence peddling operation as the brand. 18b. Biden family members and business associates repeatedly used code and secrecy to hide Joe Biden's participation in the Biden family influence peddling operation. 23c. The Biden conspiracy to peddle influence generated millions of dollars for the Biden family and their business associates from foreign sources. 26d. The Biden family and their business associates utilized a system of money transfers and complexity to mask foreign funding sources. 32e. The Biden family used a network of close associates to entangle their financial interests with Joe Biden's. 36f. The Biden family did not provide services to merit the millions of dollars paid to them. 39-2. The Biden family and business associates leveraged Joe Biden's official position for financial benefit with Joe Biden's awareness and participation. 43A. In April 2014, a Kazakhstani oligarch wired $142,300, the exact price of Hunter Biden's sports kit, to a bank account used by Mr. Archer and Hunter Biden. 43B. Hunter Biden peddled Vice President Joe Biden's political influence to benefit monetarily from Russian business associates. 49C. Hunter Biden and his business associates leveraged Vice President Biden's political power to obtain millions of dollars from a corrupt Romanian businessman. 55D. Evidence suggests Vice President Biden changed official U.S. policy to produce a positive outcome for Burisma, a Ukrainian natural gas company implicated in a years-long corruption investigation. 61E. The Biden family earned millions of dollars from numbers business deals with Chinese companies closely tied to the Chinese Communist Party by selling access to Joe Biden while he was vice president and later preparing to run for president. 76.3. The Biden family received other financial benefits, including forgiven and interest-free loans, that they likely would not have received but for Joe Biden's official position. 148A. James Biden received large cash loans, many of which remain unpaid, from numerous individuals who previously made political contributions to Joe Biden, as well as a bankrupt healthcare company. 148B. Democrat donor Kevin Morris has loaned $6.5 million to Hunter Biden in order to protect Joe Biden's presidential campaign. 168. 4. As president, Joe Biden provided access and rewards to his family's benefactors, as demonstrated by Hunter Biden's sale of amateur art for exorbitant prices. 182. President Biden and the Biden-Harris administration obstructed Congress and the criminal investigation of President Biden's son. 192. President Biden and the White House obstructed congressional investigations. 192. President Biden's White House obstructed Congress's investigation of his mishandling of classified materials. 193. President Biden's White House has obstructed Congress from receiving relevant documents from the National Archives. 209. President Biden and the Biden-Harris administration obstructed the criminal investigation of his son and the committee's impeachment inquiry. 212. Federal law enforcement began investigating Hunter Biden nearly 7 years ago. 213. The special treatment the Justice Department afforded Hunter Biden stemmed from the politically sensitive and significant nature of the criminal investigation. 215. After the IRS whistleblowers came forward, the Biden Justice Department attempted to cover up its wrongdoing. 254. President Biden had prior knowledge of Hunter Biden's intent to defy 2 duly authorized congressional subpoenas. 270. Impeachment inquiry witnesses lied to the committees to protect Joe Biden. 273. The Biden Justice Department prevented the home confinement of Jason Galanis with the explicit goal of stopping him from testifying to Congress about Hunter Biden's most serious crimes that implicated President Biden. 286. Conclusion. 291. Procedural background. Since the beginning of the 118th Congress, the Oversight Committee has conducted legislative oversight investigations into allegations that President Biden aided his family in peddling influence to foreign parties during President Biden's tenure as vice president. The Oversight Committee gathered substantial evidence that during and after the Obama-Biden administration, multiple Biden family members leveraged Joe Biden's official position as vice president, or anticipated position as president, for personal benefit of the Biden family, and then Vice President Biden was complicit in this conspiracy. 17. In the spring of 2023, 2 whistleblowers disclosed to the Ways and Means Committee their concerns that the Biden-Harris administration had been obstructing a criminal investigation into President Biden's son, Hunter Biden, relating to his foreign business dealing. The 2 whistleblowers, who were closely involved in that investigation, detailed several ways the Department of Justice deviated from its standard processes in a way that afforded Hunter Biden special treatment, including allowing the statute of limitations to lapse on serious felony charges, slow-walking the investigation, informing defense counsel of future investigative actions, and preventing line investigators from taking otherwise ordinary investigative steps. 18. The Ways and Means Committee and the Judiciary Committee began investigating these allegations. In September 2023, based on evidence gathered to that point, Speaker of the House Kevin McCarthy commenced an inquiry to examine whether sufficient grounds existed to draft articles of impeachment. 19. In December 2023, the House ratified the inquiry and authorized the committees to continue gathering evidence. 20. In the course of the investigation, and despite dilatory and obstructionist tactics of witnesses before the inquiry and the Biden-Harris White House, the committees have conducted over 30 transcribed interviews and depositions, issued over 30 subpoenas, reviewed millions of pages of documents, and held 6 markups and hearings. The evidence detailed in this report is drawn from this material. 17. See generally Memorandum from Major COMM Staff, HCOMM on Oversight and Accountability, to COM. Members. New evidence resulting from the Oversight Committee's investigation into the Biden family's influence peddling and business schemes, March 16, 2023, hereinafter First Bank Memo, Memorandum from Major COMM Staff, HCOMM on Oversight and Accountability, to COMM members. Second Bank Records Memorandum from the Oversight Committee's investigation into the Biden family's influence peddling and business schemes, May 10, 2023, hereinafter Second Bank Memo, Memorandum from Major COMM Staff, HCOMM on Oversight and Accountability, to COMM members. Third Bank Records Memorandum from the Oversight Committee's investigation into the Biden family's influence peddling and business schemes, August 9, 2023, hereinafter Third Bank Memo, Memorandum from Major COMM Staff, HCOMM on Oversight and Accountability, to COMM members. Fourth Bank Records Memorandum from the Oversight Committee's investigation into the Biden family's influence peddling and business schemes, November 1, 2023, hereinafter Fourth Bank Memo. 18. See transcribed interview of Gary A. Shapley, Jr., HCOMM on Ways and Means, May 26, 2023, hereinafter Shapley interview. See also transcribed interview of Joseph Ziegler, HCOMM on Ways and Means, June 1, 2023. Hereinafter Ziegler interview. 19. Press release. Representative Kevin McCarthy, Speaker of the House of Representatives. Speaker McCarthy opens an impeachment inquiry, September 12, 2023. 20 HRES 918, 118th CONG, 2023, HRES 917, 118th CONG, 2023. The constitutional standard for impeachment. The Constitution grants the House of Representatives the sole power of impeachment. 21. In 2019, during the impeachment of President Donald Trump, House Democrats asserted that high crimes and misdemeanors are primarily defined by 3 types of misconduct: 1. Abuse of power, 2. Betrayal of the national interest through foreign entanglements, and 3. Corruption of office and elections, any one of which constitutes an impeachable offense. 22. This definition is highly relevant to the current impeachment inquiry into President Joseph R. Biden Jr. Abuse of power. Abuse of power is unquestionably an impeachable offense, and one that constitutional law professor Jonathan Turley described as encompassing a wide range of self-dealing, obstruction, and misuse of federal authority maneuvers, and may include the use of federal staff to obstruct or frustrate efforts to investigate corruption or abuse. 23. House Democrats in the 2019 impeachment of President Trump described abuse of power as the exercise of official power to obtain an improper personal benefit, while ignoring or injuring the national interest. 24. In testimony to the Oversight Committee, Professor Jonathan Turley explained that it is not necessary for the improper benefit to be received directly by the President. 25. As he explained, to say that millions of dollars going to his family would not be considered a benefit to Joe Biden is legally and logically absurd. 26. Clearly, it would be an abuse of power, and thus an impeachable offense, if President Biden participated in his family's influence peddling scheme. 27. An abuse of power may also be present even if, as some claim, the Biden family was only selling the illusion of influence and access to President Biden. 28. In other words, as Professor Turley explained, it is not necessary for the House of Representatives to show that the dealings involved a quid pro quo to rise to the level of an impeachable offense. 29. Quite simply, it is not necessary for any of the Biden family's 21 U.S. Const. Art. 1, 2. 22 H.R. Rep. No. 116-346, at 4, 2019. 23. The basis for the impeachment inquiry of President Joseph R. Biden, hearing before the HCOMM on Oversight and Accountability, 118th CONG, at 23, 2023, written testimony of Jonathan Turley, Professor, Geo-Washington University L.S.Ch. Hereinafter Turley testimony. 24 H.R. Rep. No. 116-346, at 44, 2019. 25 Turley testimony at 15, 26. 26 ID at 15. 27 CID at 12. If President Biden was engaged in selling access or influence, it is clearly a corrupt scheme that could qualify as impeachable conduct. ID at 15. If President Biden was aware of money going to his family in exchange for influence or access, it would constitute an impeachable offense. 28 CID at 25 to 26, rebutting the oft-quoted illusion defense to influence peddling allegations. See also Jonathan Turley, Illusion of Influence, the media moves the goalpost again on Biden corruption coverage, RESIPSAL Acquitter, August 11, 2023, asserting that the illusion defense relies on ignoring significant evidence of the Biden family's corrupt dealings and demanding evidence of corruption, such as direct payments to President Biden, that is unlikely to exist in any corruption case due to its obviously incriminating nature. 29 Turley testimony at 25. Professor Turley offered his personal view that a quid pro quo is a touchstone for a bribery-based article of impeachment, but did not say the same for any of the other impeachable offenses he discussed. Business partners to have actually received influence or access to President Biden, though evidence supports they did in fact receive both. 30 The question, then, that the House must answer is whether President Biden was aware of his family's influence peddling scheme, 31 and participated in it. If the answer is yes, that is clearly an abuse of power and an impeachable offense. As House Democrats defined abuse of power in 2019, it may also encompass the betrayal of the national interest through foreign entanglements. 32 Betrayal of the national interest through foreign entanglements is an impeachable offense, they explained then, wherein the president or vice president uses his foreign affairs power in ways that betray the national interest for his own benefit, or harm national security for equally corrupt reasons. 33 To the extent the questionable conduct occurred prior to the president assuming office, Professor Turley explained that the House has previously included pre-office conduct in articles of impeachment. 34 For example, in 1912, the House impeached Judge Robert Archibald, who was a federal district court judge and then a federal circuit court judge. When the House adopted 13 articles of impeachment against him, Archibald was a federal circuit court judge, but 6 articles were based solely on his conduct as a district court judge, and another was based on his conduct both as a district court judge and as a circuit court judge. More recently, in 2010, the House impeached Judge G. Thomas Porteous, Jr., who was a state court judge before being appointed to the federal bench. One of the articles of impeachment that the House adopted against him was based solely on events that occurred while Porteous was still a state court judge, and a separate article was based on his conduct both while a state court judge and while a federal judge. Additionally, in 2021, House Democrats created precedent for impeaching a former president in a retroactive action. 35 Based on this precedent, Professor Turley correctly concluded that the House could impeach Joe Biden from his prior office as vice president over these allegations. 36. Another way in which the president may commit impeachable abuse of power is by maintaining false denials of his misconduct or using White House staff to maintain false claims or resist disclosures. 37. Professor Turley testified that lying to the public for years in denying knowledge of his son's business dealings may constitute such an offense. 38. While President's 30 CID at 25 to 26. 31 CID at 25. The question is whether President Biden was entirely unaware of this massive and lucrative enrichment scheme. 32 CHR Rep No. 116 to 346, at 79 to 81, 2019. 33 ID.AT 50. 34 Turley testimony at 30 to 31. 35 ID at 29. Similarly, in 1876, the House impeached Secretary of War William Belknap shortly after he resigned from office. The House and Senate both expressly determined after debating the matter that they could respectively impeach and try a former federal officer. Jaredp Cole and Todd G. Harvey, Kong. RSCH. Serve, LSB 10565, The Impeachment and Trial of a Former President, at 4, 2021. 36 Turley testimony at 29, see Generally Brian C. Colt, The Constitutional Case for the Impeachability of Former Federal Officials, An Analysis of the Law, History, and Practice of Late Impeachment, 6 TX Rev L and Poll. 13, 2001, arguing that former federal officials may be impeached. 37 Turley testimony at 21, 25. 38 ID at 25. Professor Turley also suggested that President Biden's and White House staff's false statements may be charged as obstruction. CID at 21, stating that impeachable obstruction may also encompass efforts by President Biden to maintain false accounts of his lack of knowledge or involvement in the alleged influence peddling efforts by his son and his associates. ID at 30, White House staff is now actively engaged in denying allegations raised. May have some leeway in denying allegations of corruption. The issue is whether a president fostered a false narrative in the knowing denial of key facts, particularly in relation to Congress, investigators, or sworn proceedings. 39 Such an allegation was included in the articles of impeachment filed against President Nixon. 40 Finally, in the House's consideration of potential impeachment articles, whether the president's conduct constitutes a criminal offense is not dispositive. In 2019, House Democrats asserted that impeachable offenses need not rise to the level of criminal conduct, noting that Congress reached the same conclusion during the impeachments of President Nixon and President Clinton. 41 Although the matter remains unsettled, most scholars agree that criminal conduct is not needed under the constitutional standard for impeachment. 42 Historical precedent also supports the position that criminality is not required for conduct to rise to the level of an impeachable offense. 43 The House may therefore impeach President Biden for non-criminal conduct that significantly impairs the political system or betrays the public trust. 44 2. Obstruction of justice or obstruction of Congress. Obstruction of justice or of Congress is another impeachable offense encompassing a wide range of potential misconduct. 45 Generally, obstruction occurs when an individual, including the president, corruptly endeavors to impede or influence an investigation or other proceeding, and the word corruptly is understood to mean with an improper purpose. 46 While there is room for debate as to what may constitute an improper purpose, it is apparent that, at the very least, if the president interferes with an investigation because he worries that it might bring to light criminal activity that he, his family, or his top aides committed, then he acts corruptly, and thus criminally. 47 Additionally, the House need not find that President Biden's misconduct met the standard for obstruction of justice provided in federal statutes by the House committees, and a war room has reportedly been established within the White House. Such measures can lead to the very same allegations raised against prior presidents in efforts to obstruct investigations or mislead the public and Congress. 39 ID at 21 N.70. 40 H.Com. On the Judiciary, Impeachment of Richard M. Nixon, President of the United States, H.R. Rep. No. 93 to 1305, at 2, 1974, alleging that President Nixon made false or misleading public statements for the purpose of deceiving the people of the United States. 41 H.R. Rep. No. 116 to 346, at 56 to 62, 2019. 42 C. Example James C. Phillips and John C. Yu, you're fired, the original meaning of presidential impeachment, 94 S. Cal. L. Rev. 1191, 1196, 2021, Keith E. Whittington, A Formidable Weapon of Faction. The Law and Politics of Impeachment, 55 West Ake Forest L. Rev. 381, 403, 04, 2020. 43 C. Example Jared P. Cole and Todd G. Harvey, Kong. RSCH. Serve, R46013, Impeachment and the Constitution, at 42, 2023, He notion that only criminal conduct can constitute sufficient grounds for impeachment does not track historical practice. 44 CHR Rep. No. 116 to 346, at 37, 2019, impeachment is reserved for offenses against our political system, Alan Z. Rosenstein, The Virtuous Executive, 108 MN. L. Rev. 605, 668, 2023, criminal conduct is not required for impeachment, as long as the President's actions constitute a sufficient serious abuse of power or breach of public trust. He Federalist No. 65, at 338, Alexander Hamilton, George W. Carey and James McClellan eds, 2001, stating that impeachment applies to offenses which proceed from the abuse or violation of some public trust. 45 C. Turley Testimony at 19 to 22, H.R. Rep. No. 116 to 346, at 145 to 48, 2019. 46 Daniel J. Hemmel and Eric A. Posner, Presidential Obstruction of Justice, 106 California L. Rev. 1277, 1282, 2018. Quoting 18 U.S.C. 1515, b. 47 ID. Regarding obstruction of justice. 48 Instead, it is enough to show that the President's actions constitute the kind of wanton constitutional dereliction captured by the phrase high crimes and misdemeanors. 49 As such, any attempt by the President to distort an otherwise valid government investigation is a basis for impeachment that is affirmed by the precedent of President Nixon's impeachment. 50 Likewise, following the standard set by House Democrats in the impeachment of President Trump, impeding an impeachment inquiry may amount to impeachable obstruction. 51 In 2019, House Democrats explained that when a president abuses his office to defy House investigators on matters that they deem pertinent to their inquiry, and does so without lawful cause or excuse, his conduct may constitute an unconstitutional effort to seize and break the impeachment power vested solely in the House. In that respect, obstruction of Congress involves the exercise of official power in a way that, on its very face, grossly exceeds the President's constitutional authority or violates legal limits on that authority. 52 Importantly, again according to House Democrats in 2019, as a matter of constitutional law, the House may properly conclude that a President's obstruction of Congress is relevant to assessing the evidentiary record in an impeachment inquiry, meaning that here the President illegally seeks to obstruct such an inquiry. The House is free to infer that evidence blocked from its view is harmful to the President's position. 5348 Ch. On the Judiciary, impeachment of William Jefferson Clinton, President of the United States, H.R. Rep. No. 105 to 830, at 181, 1998. The actions of the President do not have to rise to the level of violating the federal statute regarding obstruction of justice in order to justify impeachment. Philip C. Bobbitt, Impeachment, A Handbook, 128 YLLJ Forum 515, 581, 2018, the standards of a criminal statute, which are supposed to be quite rigorous in our system, and which generally require scienter, or knowledge of wrongdoing, on the part of the defendant, cannot substitute for the standards of impeachment by the House and conviction by the Senate. The standards for impeachment need not depend upon the President's actual intent to commit a crime, constitutional or otherwise. 49 Philip C. Bobbitt, Impeachment, A Handbook, 128 YLLJ Forum 515, 581, 2018. 50 ID. 51 HR Rep NO 116-346 at 145-48, 2019. 52 ID at 145-46, quoting a majority staff of HCOM. On the Judiciary, 116 TH Kong, Constitutional G Rounds for Presidential Impeachment, at 18, COMM Print 2019. 53 ID at 67-68. President Biden abused his office by engaging in a conspiracy to peddle influence bank records, witness testimony, and contemporaneous communications between and among the Biden family and their business associates expose a years-long pattern of influence peddling and grift centered around and facilitated by Joe Biden. President Biden knowingly participated in a conspiracy to monetize his office of public trust to enrich his family. Abuse of power encompasses a wide range of self-dealing, obstruction, and misuse of federal authority maneuvers. 54 Under the standard articulated by House Democrats in 2019, impeachable abuse of power occurs when the president exercises official power to obtain an improper personal benefit, while ignoring or injuring the national interest. 55 President Biden's actions are consistent with this standard. Joe Biden allowed his family to monetize his political influence and access by selling it to foreign actors. President Biden participated in a scheme in which foreign business interests were led to believe that they would gain access to him if they were to pay substantial amounts of money to his family. The payments amounting to millions of dollars from foreign and domestic sources to Biden family members coincided with Joe Biden's actions to further this conspiracy. Joe Biden repeatedly demonstrated to his family's business partners that his family had access to the vice president or, later, the Democratic frontrunner for president. While defenders of Joe Biden have sought to characterize these activities as mere illusions of access to Joe Biden, this is wrong. Foreign business associates of the Biden family in fact received actual access to Joe Biden in private settings that were never meant to be uncovered, as is demonstrated by a shifting series of stories to deny and then minimize Joe Biden's centrality to the influence peddling schemes. Joe Biden knew about and participated in this conspiracy to prioritize the Biden's personal interests above Joe Biden's oath to well and faithfully discharge the duties of the offices he has held or would hold, demonstrating a profound selfishness and greed at the expense of the nation's future and welfare. Joe Biden's actions to facilitate his family's enrichment schemes not only meet the threshold for impeachable conduct, his actions exceed it. In testimony to the Oversight Committee as part of the impeachment inquiry, Professor Jonathan Turley explained that if President Biden was aware of money going to his family in exchange for influence or access, it would constitute an impeachable offense. 56 The evidence presented in this section demonstrates not only Joe Biden's knowledge of his family's influence peddling, but his facilitation and participation in it. This influence peddling took several forms: money paid to Biden family members by foreign individuals or entities seeking access to or influence over the vice president, millions of dollars paid to Biden family members in the form of forgivable loans seeking to remove a political liability for Joe Biden, and, in its most recent form, the sale of art by Hunter Biden for exorbitant prices to Democratic donors, one of whom received a political appointment. 54 Turley testimony at 23. 55 HR Rep NO 116-346 at 44, 2019. 56 C Turley testimony at 15, ID at 12. If President Biden was engaged in selling access or influence, it is clearly a corrupt scheme that could qualify as impeachable conduct. The committees reviewed the Biden family's financial practices and sources of income from 2009 to the present. This was a complex process, as members of the Biden family, particularly Hunter Biden and James Biden, often used a complicated system of third parties. Limited liability companies, delayed transfers of incremental payments, and categorized certain financial transactions as loans to seemingly obfuscate the source and nature of the payments to Biden family members, including Joe Biden. Additionally, the parties to various business contracts or agreement often did not memorialize the Biden's value to any particular transaction with any degree of specificity, a fact certain witnesses explained was intentional. 57. The committees have established a consistent pattern of behavior by President Biden and his family, which is based not on speculation or any singular piece of evidence but, instead, thousands of pages of bank records and multiple witnesses' accounts of a conspiracy to use America's high offices to reap millions of dollars for the Biden family. Although the president is now 81 years old and appears to suffer from diminished mental capacity, 58. It is important to note that much of the president's wrongful conduct occurred while he was lucid and during the peak of his political career. This section of the report evaluates his state of mind at the time of the offenses. The Biden family business model centered on Joe Biden's influence and positions of power in the federal government. Biden family members did not provide services or value of any discernible type other than access to Joe Biden. There is no business. There is no product. The Bidens sold the brand. 59. That brand was Joe Biden. President Biden inappropriately wielded the power of the office of the vice president to influence potential business deals that financially benefited his family by repeatedly meeting, talking, and interacting with his family's business associates at dinners, on the golf course, over the phone, and at the White House. 60. A Biden business associate, Devin Archer, testified how the Biden brand was used to retain business and how Joe Biden met privately with many of the business associates who paid his family millions of dollars. 61. The Bidens did not have a golf course, real property, a clothing line, or media business. They sold political influence, and their business included consulting without being lobbyists. The committees have traced wires from foreign sources to Hunter Biden with Joe Biden's home address and money from the Biden family's transaction with a Chinese conglomerate going to Joe Biden's personal bank account. 62. But to be clear, that is unnecessary. The law contemplates and the Justice Department has initiated prosecutions for payments to family members who agree to or accept payments in relation to corrupt acts. See, example 18 U.S.C. 201. 63. Payments to family or their companies can be akin to payments to the public official. 57. See Galanis, interview at 120. 58. Stephen Collinson, Biden's disastrous debate pitches his re-election bid into crisis, CNN, June 28, 2024. 59. See Generally Archer interview at 27-28, 29-30, 53-55, 85-88. 97-98. 60. CID at 41-42, 51-52, 80, Galanis interview at 10, transcribed interview of Tony Bobulinski, HCOMM on Oversight and Accountability and HCOMM on the Judiciary at 262, February 13, 2024, hereinafter Bobulinski interview, deposition of Robert Hunter Biden, HCOMM on Oversight and Accountability and HCOMM on the Judiciary at 18-19, February 28, 2024, hereinafter Hunter Biden deposition, transcribed interview of Eric Schwerin, HCOMM on Oversight and Accountability and HCOMM on the Judiciary at 131-32, January 30, 2024, hereinafter Schwerin interview. 61. See Generally Archer interview. 62. Fourth Bank memo at 5-10. 63. 18 U.S.C. 201. Subpoenaed bank records revealed Hunter Biden, James Biden, their associated companies, and certain other Biden family members received over $18 million from foreign sources. 64. Additionally, bank records establish that, when also including Biden business associates and their companies, the international influence peddling schemes totaled over $27 million from foreign sources during the same time period from 2014 to 2023. 65 The Bidens, their business associates, and their related companies received funds from individuals and entities associated with Russia, Ukraine, Kazakhstan, China, Romania, and Panama. These figures do not include the approximately $8 million in loans Hunter Biden and James Biden received from Democratic benefactors such as Kevin Morris, Joey Langston, and John Hynansky. 66 Those loans are discussed in detail further below. The amount of money Hunter Biden, James Biden, and even Joe Biden sourced from foreign and domestic companies and then later described as a loan, often without documentation to show the terms of the loan and much of which was never repaid, is alarming. In total, the committees have accounted for over $35 million sent to Biden family members, their companies, and business associates since 2013. 67 However, the committees have not identified legitimate services warranting such lucrative payments. No one has been able to assert any plausible reason for the Bidens receiving this much money from foreign sources and Democratic benefactors. And to the extent that reasons were provided, the witnesses' descriptions of the purported services provided do not justify the amount of money paid to them. Moreover, Joe Biden was involved in nearly every foreign business deal identified by the committees. While the Biden family's influence peddling racket involved a wide range of corrupt dealings across multiple countries, their various endeavors all fundamentally represent an attempt to profit from President Biden's office and the power entrusted to him by the American public. 68 Joe Biden's years-long acquiescence to and participation in this conspiracy is described in this section. 64 Robert Hunter Biden and James Biden criminal referral for hereinafter referral. 65 ID, see also ID 7. 66 See letter from Kevin Morris's counsel to General Counsel, HCOMM on Oversight and Accountability, January 25, 2024. See transcribed interview of James Bryan Biden, HCOMM on Oversight and Accountability and HCOMM on the Judiciary at 171, 174-75, February 21, 2024, hereinafter James Biden interview. This is a conservative estimate as there are additional, significant loans James Biden received from AmeriCorps and Michael Lewitt. 67 See referral 6-7. Letter from Kevin Morris's counsel to General Counsel, HCOMM on Oversight and Accountability, January 25, 2024, see generally First Bank Memo, Second Bank Memo, Third Bank Memo, Fourth Bank Memo. Note, this is a conservative estimate as there are additional, significant loans James Biden received from AmeriCorps and Michael Lewitt. 68 CF Turley testimony at 25. Just as influence peddling is a form of corruption that the United States has sought to combat on a global scale, it is still corrupt if you have no plans to fulfill the deal. You are still turning an office into a commodity for corruption.